Okay, right. So yeah, thank you so much for joining us. We've been very much looking forward to hosting this webinar, one of our specific, topical webinars with Alison around estate planning. On estate planning. We organised this along with a series of other webinars around the sort of legal LPAs or whatever it is to do with managing wealth and in the later part of your life, because we realise that the building the annex is often the end of a very long journey of decisions that have to be made, whether it's with siblings, children, ownership of land. There's many things that have to be considered and hurdles jumped to get to the point where you're at where you can proceed with building an annex. And we're not experts in all those fields, far from it. There are people who spend all their life dedicated to being, training and learning and understanding our legal and financial systems and whatnot in the UK. So, like everything we do, at iHus, we do bring in specialists for areas that we don't specialise in, whether it's engineering or groundworks or whatever. So today we're very pleased to introduce Alison from the Legal Studio, who's a legal professional. And we'll go through a presentation with you. We'll take about half an hour, 40 minutes, covering a number of sort of topical top-line points around estate planning. I think it's important to understand that everyone's situation is specific. No, I wouldn't have thought two circumstances are ever quite the same. And so you're going to get a broad introduction into it all. However, if you do have specific questions, we can try and answer them at the end, or if it's going to require more time, I'm sure Alison will arrange a 15-minute chat with you separately to discuss your circumstances. So I'm going to hand over now to Alison, and as I said, please drop your questions into the chat box as we go, or feel free to put the audio on and ask a question and interact. So I'm going to hand over to Alison. So thank you again, and thank you for joining.
Thank you. So just a brief introduction about myself. So my name's Alison Gregory. I work for a company called Legal Studio Solicitors, primarily based in Manchester and Leeds, but we do cover all of the nation in reality. And I'm based in our Sheffield hub at Callum Island. I've worked in the legal sector coming up to 20 years, specialise in two areas of law, which is private client, which is your wills, estate planning, probate, estate management, and family law. And the family law is very much around separations, disputes over children matters and divorces. It comes quite hand in hand realistically, and I think this is why it's important to have this webinar today, that both of those elements can potentially impact on any potential build of an annex, and making sure that if you're going into this, you are going into it with your eyes open and aware of all the possibilities, but also making sure that you've got the protection at day one. So rather than having to retrospectively backpedal, it's making sure that you are fully aware of the consequences of doing this, but also having the protection in place, which we should all have in any event, regardless to whether we're building an annex or how we're managing it. Estate plan is something that we all really need to consider, particularly because there are two things we are certain on in life, which of course is that we will pass away, and taxes. So it's making sure that you have the right advice. And of course, anyone who wants anything specific to them or their personal circumstances, I'm more than happy to jump on any kind of call or Teams with you following today.
Sorry, before we carry on, I forgot to introduce myself. I'm James Lund-Lack. I'm the Managing Director at iHus. So whilst Alison could answer questions around estate planning, if you have any questions specific about the annex or the iHus, which or Alison needs some more detail, then I'm here to help. But most of the talking will be done by Alison. So we'll crack on now with the presentation.
Perfect. So we'll go on to our first slide, which is very much about property and rights of occupation in there. It's all about the ownership, that when we look at doing these annexes, which I must say is potentially something that as are ahead of the future, really. They're ahead of the game with this. That it's something that I think more people will look at, particularly as we're seeing such a significant rise of people sadly being received into the care system, whether that's nursing or residential care. So again, it's making sure that the property rights and ownerships are covered in any kind of agreement. So with the annex ownership, and of course James can give you more information on this, but the detail of how they will work is very much that the annex would be owned by the property owner. So whether it's your property that you are building on and it's for a loved one, or whether it's you that intends to sell or use some of your capital to build on a loved one's property, it gives you that opportunity. But it's being fully aware that the annex and the ownership of the annex, regardless to who may have paid for the build, will actually form part of the landowner's property. It's very specific and very clear that you need to be aware of that. The reason being is that you have no legal ownership or rights then over not just the annex, but the whole property and land that may be on. When you look at separate title, there is another element to that. And what a separate title is, and people talk about, can be where people have separated an element of their properties to enable a build to happen. That becomes into a completely domain that is quite complex. There's different planning permissions, different applications that could be made. So it's not always sensible to do when we're looking at the annexes. And that is something, of course, that the team here can advise you on as to why we don't recommend the separated title on them. The lack of separate title, of course, then confirms the ownership, so the legal title to that. The reason, therefore, it is so important to have legal agreements is to protect you, to protect your investment or protect the investment of any third parties. As if you do not have any legal interest or beneficial title or even equitable title within that annex, it's making sure that you are protected as much as possible. And formal agreements between you and whoever is the landowner is important, not just to cover the fundamentals of certain rights, obligations, but very much the responsibilities, as trivial as a utility provider may be and who pays for the utility bill, or any increase in potential insurance policies and the occupation. When we look at the occupation, a lot of people will be more worried of, well, if I invest money into an annex or somebody invests it into the annex, what if the landowner is forced or has to sell that property? Or they predecease me. So I'm in an annex where I have no beneficial or legal interest in, but that person, that individual, the landowner sadly passes away or their circumstances change. Can this be protected? What would happen with me in those circumstances? Would I be forced to leave the annex? And as a result, my investment would be also within that annex and that property I will have no financial control over. So incorporating legal agreements where it's clear not only on who is responsible for the bills, but having a life interest or right of occupation can protect that rights. The benefit of that is saying that whomever may be living in the annex, it's really an agreement between all parties entering into it at the time that there is a full intention and knowledge that you will continue to live in that annex for as long as you are able to live in that annex, or of course until you sadly pass away. So it's protecting that occupation. The benefit of the legal agreement protecting that occupation, of course, is making sure that there isn't external third-party matters that may result in you having been removed from the property. So usually when you're looking at annexes or looking at moving in with any individuals, there is an agreement at the time and it's based on the circumstances that you are in as at that time. We all know that it's unlikely that when you're going into it, there's any intention or underlying sense that someone would kick you out of that, ask you to leave. But there can be circumstances such as a divorce, a separation, bankruptcy, the landowner predeceasing. Those circumstances are completely separate. So it's not something that you can foresee. It's not something at the time that you can manage. By having a legal agreement with your life interest, a right of occupation over the annex, really will put off any third-party interests. So, for example, if it was a married couple separating and the courts was looking at a forced sale of the home, the right of occupation would mean that the courts would not force sale of the property and it would be on a deferred sale basis. The deferred sale would be subject to the right of occupation. So again, would protect your interest, not only potentially the value of your interest from any matrimonial asset part, but also protect your residential property, so protect your home and where you live. Without an agreement, the difficulty is the court has to decide, actually, should we defer any interest in this property or should we force sale? Is it excessive for that individual needs? And sadly, when they look at needs, they're looking at the needs of the parties, not any third party who may be resident on their land, whether in an annex or anything else. But the legal agreement, having it at the outset, really just provides that protection. That also looks at trust agreements as well, and why I believe it's really important when we're doing this is that trust agreements should be in place. A trust agreement, in essence, is confirming that you have invested, if you are the individual what's paying for the build, you have invested X £1,000 towards the build, and therefore you have an equitable interest in that property. So you may not be on the title deeds, you may not be on any mortgage or any financial agreements, but you have a legal document, a legal instrument, which confirms that you have X amount or X percentage of value within the body of the landowner's property. A lot of that, you don't recall that agreement. So because you're expecting to live with family, friends, whomever it may be, there is an element of trust there. But should you need that agreement, and again, this can be subject to bankruptcy proceedings, it could be that businesses are falling apart, it can be divorce and separation, it will ring fence your initial investment into the property to make sure that either you will get that investment back following a sale, or indeed whoever the landowner may be, that you may have an agreement, if it's a child, if it's a loved one, that they would get that initial investment back. So rather than it being split 50-50 potentially, or somebody, the insolvency trustees in bankruptcy, or any third party claiming it, where there's personal guarantors, it ring fences your initial investment, that you can get that back at a later date. The protection of that trust, of course, will provide security for the landowners, but also provide security for you, that circumstances change, that you are forced out of that property. You know, potentially you will get the money back out of there, which will allow you to purchase another residential property or whatever may be required moving forward. So it's protecting that interest. We see so many times that people don't do that because it's usually a family agreement, there's trust involved, and there's very much that will never happen to us. But sadly, circumstances can change, and as a result of that, when you don't have the agreement in place, there is no evidence, there's no transactional trail of what the intention is. Without the transactional trail, a court will very much deal with it as a gift, that it's been gifted outright to the individuals, and therefore you have no interest. So the trust really provides that protection. It also provides that long-term security. So having the written agreements covering the initial investment, your life interest, protects your long-term security, that you know that when entering into this, that annex is going to be your home, and nobody, not even third parties, can force you out of that. You have that right over that property. And of course, as much as we hope that there's not going to be any fallouts, as times change, circumstances change, and sometimes input from third parties, the legal agreement just is transparency for all parties from day one to when you final rest in place. So it's about protecting your ownership and your right over that property, particularly when you're not on the title deeds. There is a lot more involved in that, and that's why I'm not going to expand any further on that, because the details of it can be quite difficult, or it can be different circumstances. So it's not unusual that some of these trust or these life interests can have trigger events, that there can be trigger points where these are actually, there's exit clauses within them, but that is all subject to your personal circumstances. If we go on to the next slide, inheritance and estate planning. So this is primarily where everything comes hand in hand. So if you are selling your home, or you have capital assets and you're using that to purchase the annex, because you are purchasing the annex in essence in somebody else's name or your name, and you have been the beneficiary of that money, there is an element that there's a gift with a reservation of an interest. The reservation is very much because you maintain an element of that gift by way of living in the property. So you continue to live in that property and therefore reserve a benefit to it. I think that's it. You reserve a benefit in that. As a result of that, it can of course look at how this impacts on inheritance tax. In actual fact, it can have really positive stance on inheritance tax. So when we look at inheritance tax for an individual, we all receive a tax allowance of £325,000 each as an individual. So as a married couple, you will have a tax allowance of £650,000. The reason I say as a married couple is automatically, if you leave your estate to a spouse, you also will leave them the benefit of your inheritance tax threshold, meaning on the second death, you actually have a double taxation threshold, so it'll be 650. In around 2017, the government realised that actually for one individual, an unmarried person, £325,000 as a tax-free threshold just wasn't enough. Simply as house prices were rising, and particularly properties down south, I must say more so than up north, but it meant that people were going over that inheritance tax threshold and therefore having to find the funds either by way of equity release or from other sources to pay the tax. The tax over that came to 40% of anything over your 325,000. So in 2017, the government introduced what we call the residential nil rate band. And how the residential nil rate band worked was it stated if you lived in a residential home that you earned as at the date of your death, you could claim an additional allowance to your £325,000 allowance. So it gave you up to, which currently stands at £175,000 each, again transferable on death to a spouse. So you can claim an additional £175,000 toward your tax-free allowance on death. You are only, however, eligible for that if you leave that property to your direct descendants. So it must be to your children, to your grandchildren, and that does, of course, include stepchildren. You do not qualify for it if you leave it to nieces, nephews, siblings. It's only your direct descendants. Similarly, with the nil rate band allowance, if you are particularly wealthy and your estate goes over 2 million, you will lose that inheritance tax, the nil rate band allowance, pound for pound as you go over the £2 million mark. But potentially you can have, as a married couple, up to £350,000 towards the value of property tax-free, plus the £650,000 allowance, which is our standard allowance. The worry, of course, with this is that if you sell your residential home and then come to live in an annex, which you no longer own because that is actually owned by the landowners, how will that impact? Will you lose the residential nil rate allowance? Potentially, yes, because you no longer own a residential home. However, you can make a claim through the inheritance tax, through the HMRC, which is for downsizing. What downsizing is where somebody has sold their residential home to downsize. So later in life, they've sold a residential home to enable them to downsize. As long as we can prove a transactional trail from your residential property being sold, you inputting the money from that residential sale into the annex, you potentially can still claim the downsizing allowance. So it still allows us to claim it even though you may not be the legal owner of the annex. So you can still claim towards it. So the annex doesn't lose the residential nil rate, it just is dealt with under a different eligibility. And again, that can be quite complex in itself. So individual circumstances, of course. Potentially tax liabilities on gifting. This is something that a lot of people do not recognise. And that is that if you gift money to your loved ones, so you are gifting money to the landowner to enable the build of the annex, if you gift over your inheritance tax threshold, it will immediately create a taxable charge, because you cannot leave more than £225,000 in your lifetime as a gift without that charge becoming taxable. You then have to survive 7 years from the gift to generate a further £325,000 allowance. So if you have other assets, it's really important to do some tax planning of your assets and how this may look in practice. We then look at capital gains taxes. So we've got an inheritance tax, we've got taxable gifts, but we look at capital gains. And that, of course, is for the landowners, that if you've invested money into their property and there's a capital gains on that property, then again, that's something they may need to consider. If it is their residential home, a main residential property for the landowner, then they can look at a private residential relief on there, meaning that potentially there'll be no capital gains tax. However, if it's the circumstance that the landowner, in fact, moves somewhere else but maintain that property but don't live in it as a residential property, they can come into the realm of capital gains tax because they no longer have the residential private relief over that property. So again, it's making sure that all the circumstances are looked at both now and in the potential future. Whilst it's very difficult to foresee what may happen in 5 years, 10 years, 20 years, it's trying to realistically look of, will we all remain within this property for the rest of our years? If not, what are the consequences? And if there are taxable elements to that, that should be discussed at the time of, in essence, who's going to foot the bill for tax if it comes to it. Then we move on to our next slide, which is the importance of family dynamics. So very much as I've touched on in the last 2 slides, it's the future inheritance arrangements. That if you are gifting a lump sum of money to an individual to build the annex, the realisation is that actually it's now being gifted already in your lifetime. It is then treated as a gift, so that person has that. You have to think about your tax planning and your future inheritance planning. If, for example, you are building it onto one child's property, have you thought about what's going to happen with any other children? Is there going to be a dispute following your death that one is benefited significantly because you added to the value of their property by way of the annex, and how will that money be released? How is there going to be some equalisation of other assets, if of course there are other assets? So it's making sure that when you do this, you have factored in the future inheritance element to it of, should there be some separate proportionate distribution on the remainder of your estate because of this initial investment now? It's not always the case, and it's not unusual that I come across individuals saying, well, actually, the fact that this person is allowing me to live there and are likely to provide care, day-to-day care for me, to enable me to stay at home and within the annex for the remainder of my lifetime, as opposed to going into care, they see that as actually they should benefit more because of what they've actually contributed to your life and to your long-term and end-of-life care. But it is a discussion to have, because what you don't want to find is that you've not factored that in, that discussion's not happened, you pass away and it's a family dispute, what actually is incurring significant costs with us as solicitors and legal sector to make sure that that's happening. Again, we've touched on the loss of your residential property, that by building the annex, the landowner owns that annex and owns the property. So again, the legal agreements in place protecting your right of occupation is an absolute must, just to ensure that you're protected, but also again, transparency. Everybody knows what the intention is when you're entering into this agreement. Asset division. So the asset, again, as mentioned, can be considered as a marital asset. So without any agreement in place, the division will be looked at by the landowners. So even though you may potentially have an interest by virtue of inputting the money and fronting the money, without any legal agreement, that will be ignored, and it will potentially be up for division with any dispute separate to your individual circumstances. Practical considerations. Again, this is something, discussions that should take place before entering into an annex and spending the money, is very much the maintenance of the upkeep of the property. There needs to be transparency. There needs to be an agreement in place of who will be responsible for what at the property. As I say, that could be as trivial as bills, of who pays what proportion of the bills. It could be as much as, well, the annex covers a certain part of the garden. There's an expectation that you will manage that. There's also an element that the house itself, it all forms part and parcel, that if there's any disrepair or damage to the property, who will be responsible for that? It's making sure that there is an agreement in place of how costs are going to be associated and the maintenance is going to be upheld, both for you and the landowners, and vice versa. Insurance. Again, it's vital that the insurance is reviewed, because the annex, particularly with the annexes that you're looking at here, which are in themselves own-contained properties to some extent, it's making sure that any insurance policy adequately protects the annex as well as the main home, and of course the contents therein. That again is something that should be agreed between you, and how that is potentially funded. Markability. So this is about the property itself. If there's either an agreement between you all, so that is the landowner, the resident, the user of the annex, or whether it's following death, potentially, how will the annex impact on the property and its markability, the value? Will it potentially lower the value? With a right of occupation, there's not a likelihood that they could sell it from under the user of the annex. But in the event it lowers the value, again, how is that going to be offset? How is that going to be considered? What agreement is going to be in place that you've inputted 200,000 into a build, but realistic, like that may have only added 120,000 to the value of a property. So there is a loss there. How is that loss going to be managed, and who is going to manage that loss? So again, making sure that you have full transparency of what may happen moving forward. Then exit strategy. I think it's always important when you're looking at this is, and it's as awful as it sounds, like it's something very exciting, there's a build, there's going to be something what's going to be sustainable, but there will be an exit at some point. You know, as I say, two things we're certain of in life is the tax, that we pay taxes and that we will die. So it's making sure that there is an exit strategy in place. Has a discussion taken place of how that will work? So that could be looking at the removal or the relocation of the annex following death, that whether it's that it will no longer be on the property, it may affect things. It's making sure that that discussion has taken place. End of life or sale. So at the end of your life, that you're no longer a user and your right of occupation ceases, or there is a sale, whether by agreement or otherwise. What is the intention with that property, with the annex? Is there an element within a trustee that it would be payable to a third party? Would it be recouped by the payer of the annex? It's making sure that there is an end of life plan in place. Is it that there is an expectation that whomever the landowner is that they look to downsize at that point because you're no longer in the annex, they don't require a property at that level. There's an expectation that they will either release equity from their home to ensure that other beneficiaries of your estate are provided for, or are they expected to sell to release some equity from the property to pay out any beneficiaries? Again, these triggers need to be considered. These triggers, as well as having your declarations within your lifetime, of course, have got to be in wills. And your wills aren't very much just because you've got these in place, but for me, everybody should have a will at every age. We always think a will is something that we'll do much later in life, but realistically, life's uncertain. We never know when our demise is going to happen. We know it will, we just don't know the when, the how. So it's making sure that you've got the protection clearly outlined at every stage. The reason it's so important with wills is now it's the norm that we have blended families. It's not just a case of the law of intestacy, which came to play many, many moons ago, and that is a law that dictates what will happen in the event of a death without a will. It is outdated. Realistically, it's completely outdated. So it's making sure that your will provides for your circumstance, it provides for your family dynamic, and make sure that you are protected as much as possible. When we look at wills, we also look at power of attorneys, and power of attorneys is a different beast to your will. Your will comes into play when you pass away. So when sadly you pass away, your will nominate executors who will manage your assets, and of course will have beneficiaries within there. Your power of attorney is something that you will use during your lifetime. So your power of attorney in fact ends on death and your will takes over. So your power of attorney is during your lifetime. A lot of people will say to me, well, actually, do I need a power of attorney? I'm absolutely fine. I still completely have mental and physical capacity. It's something I'll do later. But again, capacity is something that we never know when it will change. But capacity as well takes a number of forms. It can be mental, it can be physical, it can be temporary. It doesn't have to be permanent. And we see more and more people, sadly much younger, either in accidents, having heart attacks, strokes, something what incapacitates them for perhaps a shorter period of time, but their assets still need to be managed within that short period of time. And without a legal document, a legal instrument to allow your attorneys to manage them, those assets can be frozen and can be frozen for quite a long period until either you regain capacity or indeed an application is made to the Court of Protection for what they refer to as a deputyship application. The deputyship is in essence when somebody has lost capacity and it's your loved ones applying to get attorney over you, so applying to get rights to manage your financial affairs. The power of attorney can only be done while the donor, so the individual entering into it, still has full mental capacity. And when we look at mental capacity, as I say, it can take a number of forms. It can be simply that we have clients that actually have full mental capacity, but they have really difficulty with hearing. And a lot of things now we know they're in a digital world, they're online, they're by telephone, and it may be that that individual really struggles with hearing people on a telephone, so needs to appoint someone to act as an attorney in the event they need to have any conversations. So it's all about really protecting. I can tell you a number of horror stories, but just one, for example, with a power of attorney. I sadly had a client who approached me for a power of attorney and wanted to appoint her children. The reason that that came to light was very much because her husband had sadly passed away. And how that had happened is that he got his travel insurance through his bank, a separate bank to what his wife had. So she was in different account. So he had travel insurance through his bank. They booked a cruise, they went on a cruise, and sadly the husband had a heart attack within the first few days of the cruise. As a result of that heart attack, he passed away. She contacted the travel insurance company to ensure that his body could be returned to the UK. All this lady received at the other end of a call centre was, do you have power of attorney? She didn't have power of attorney over her husband. We can only speak to the policyholder. She's not a named party on the policy. We need to speak to the policyholder. She explains that this gentleman, sadly, a spouse had passed away. Well, we need a death certificate. Again, she's on a cruise ship. She doesn't have access to a death certificate. This went on for 5 days as this lady stayed in her cabin on the cruise ship until kindly the cruise company, P&O Cruises, stepped in and they arranged for the body to be transported back to the UK, and the claim was made retrospectively from the insurance company. So that is a very small, quite trivial thing that we, as a person, we would expect common sense would prevail, and in fact the insurance company would work with you. Sadly, because the world's gone slightly data mad, that data protection as a result, unless you are the policy holder, regardless to whether you are spouse, next of kin, it doesn't matter. If you do not have legal authority to manage somebody's affairs, then sadly you will have to wait until you've got the correct information. The other power of attorney for your welfare one, which can be very important, particularly when looking at annexes, is your power of attorney for your health and welfare is very much about your day-to-day care and management. Some people will say to me, well, Alison, do we need this? Realistically, I know that I can go to my GP and I can put my spouse or my partner, my children on as a point of contact. I can authorise my GP or any medical professional to liaise with that individual. You can. I'm not going to tell you that that's incorrect. It is correct. Similarly, if you are in hospital and are unable to consent to medical treatment, you're on a life support machine, again, the doctor's consultants will automatically liaise with your next of kin to make any life-changing decisions. However, if your health deteriorated and it was care was the next level, even if you've got the annex and you believe and your family believes your care could be met at home, the decision for residential and nursing care is in fact made by a social worker. The social worker will not liaise with the family, they'll not liaise with your medical professionals. They will make a decision based on maybe a 30 to 40-minute consultation with that individual and will make a decision on capacity. If they feel you do not have capacity to return to live independent, whether that's with support services in place or not, they will place you into nursing or residential care. I'm very much of the view of, actually, are they the right people to say whether you should go and care or not? They don't know you, they don't know your family dynamic, they don't know your personal circumstances, but similarly, they're usually appointed and involved when you're at a difficult point of life. There are health issues, you have been hospitalised, but actually there can be other triggers that you're on certain medication, and as a result of that, your capacity does appear to be diminished at a certain point, but with support, with medication, that could very quickly change that you could live independent. And again, a story that I have from personal experience that my grandmother many moons ago was a carer for my grandfather who had dementia. They'd downsized, they'd got a bungalow, and she had a fall in the garden. Relatively fit and healthy otherwise, but had a fall in the garden. As a result, ended up in hospital. In hospital, she got pneumonia, she had a water infection, and she didn't sound like she had capacity. She was convinced she was seeing the Grim Reaper of an evening. She was pointing out at the residents saying, he's coming for you this evening, say your goodbyes. So she didn't sound like she had capacity. During a point when myself and my family wasn't present, a social worker did an assessment, and they did what they call a DOLS assessment, which is a deprivation of liberty. And that means that they'd made a decision that my grandmother no longer had capacity and they was going to deprive her of her liberty and put her into nursing care. As a result of that, of course, my granddad, who she was a carer for with dementia, would have also gone into nursing care. As a family, we completely disagreed with that decision and said, you've assessed her when she's on umpteen different medications, she's got a water infection, she's got pneumonia, you've assessed her actually at a really poor point. If you assess this lady in 6 months' time, the situation may be very different. The first response we get is, do you have power of attorney? Because if you don't, then there's absolutely nothing you can do. Of course we did. I go running home to get the power of attorney. As a result, my grandma did go in respite care for a short period, just particularly more to get her legs working, but returned to live independently at home. My granddad also returned to live at home when she was back to herself. They had some caring to support them, particularly in the morning, for perhaps 6 months. But after that, all the care went away, and my grandma and granddad both lived in their bungalow for another 10+ years before sadly they passed away in the 90s. But had we not got that legal document, I have no doubt that both my grandparents would have gone into care. They both would have been forced to sell their property to fund their care as well. And I doubt very much that they'd have survived the 10 years because sadly the statistics are that if we go into care, we live approximately 2 years once received into care. Whilst I don't begrudge care, and it is something that is a service that I must say it's not something I can do, the carers, I take my hat off to them. When we look at care and how much care costs, the costs are phenomenal. And in my view, not proportionate in terms of what we're looking at. So when we're looking at the annexes, even though I've outlined that potentially it could reduce the value of the landowner's property itself, there are other considerations. You have to consider if you do nothing. If you stay living in your residential home and your health deteriorated, and sadly nursing or residential care was something you looked at, they will look at your assets, so they'll look at your property, any savings, investments, any assets you've got. In assessing whether you would be a financially funded for your care, they will initially look at how much you have. If you have over £23,250, whether in property, investment, savings, then you will be a private funder of care. Once you're down to 23,250, you will move on to a contribution-based payment scheme. until you're down to 11,250, when kindly our local authority will step in and fund any remaining care that you require. So in essence, we're only allowed 11,250. There are many discussions which are saying the upper limit, the 23,250, will go up by 2025. And there's talks of it either being around 89,000 or 100,000, which of course is a positive step. But what they're not telling us that the lower limit is going to remain at the 11,250. So all that means is that actually you will be a contributor towards your care for longer. You may get an additional 6 months out of care. Care on average, anything, sort of the cheapest care homes I've been to are around £500 a week, to some of the more expensive ones, particularly around South Yorkshire, at nearly £2,500 a week to be in. So realistically, you only need to be in care a couple of years and all of your assets can be completely diluted. That you're down to your 11,250. So you have to really proportion that against, are we going to do this because this is going to be not only better for us, that we get to live independently, we've got the support of our family around us or people that care and love for us, that we can stay living it independently until our dying day. Yes, we may be losing a little bit of money because of how it impacts on the landowner. Actually, that is peanuts in comparison to going into care and losing all of the value of your assets. So again, it's just making sure that you've got the protection, you've got the advice, and we look at all the different elements. It's not just for me, we build the annex and that's your end of life plan. It's making sure that yes, you've got that end of life plan, but we've also covered everything else, that you are fully protected, that you don't look back in 5-10 years when something's triggered, a circumstance changed, and we should have done this. Doing it now, it just ties it up in a nice little bow, and you know that there's peace of mind. So I do apologise. I know I've gone through quite a lot there, but that is the end of the slide.
I was gonna. Sorry, out of interest, can you see us? You can. So my response to Alison was crumbs. I've got a lot to think about. Building the annexes is a lot easier than navigating all of that. I mean, and it is quite, it is, you know, I'm 47 this year, and I suppose I've had a fairly laissez-faire approach to all those things that are coming down the pipeline, and there's a huge amount to think about. But the two takeaways that the three I think I've taken are the one around life interest, having a trust agreement, the HMRC downsizing tax that you can apply for, the relief, and of course the whole bit around, you know, going into care and power of attorneys and wills. You know, there's a lot there to think about. But anyway, so shall we go through some questions, and I will let you know how many we've got. So first of all, I've got Paul Musgrove. I'll read out the scenario, then over to Alison, and then please feel free to keep dropping the questions in. I've got a few here that have already been sent over to us by others. And also, if you want to speak on this audio, then feel free to do so. So, Paul, scenario. I have a property with an annex valued at 1 million in total. I gift the whole property and annex to my daughter. My daughter lives in the property and I live in the annex. Is that a 1 million gift with reservation? I would prefer not to pay rent, as my daughter will have to pay tax on the income. Can the council make a claim on the property if I need care?
It will all depend on how it has been structured. If you've gifted that property to your daughter and she's the legal owner, so she's the legal proprietor, so she owns the property, then potentially, as long as she is using it as her residential home as well, you should be protected in that scenario. The difficulty that you have with that is whether there was a taxable charge when you transferred the property, given the value of the property. So even though you may have gifted it for nil value, the property can still carry a market value. So for the HMRC, what they try and avoid is that it is a deliberate disposal of an asset to mitigate either tax or care. It's not really been tested as yet as how the local authorities will look at it. So this is something what's unknown, and I think it will be different for each local authority when we consider care. That if you've got a reservation over a property, particularly if you're living in an annex or an interest in there, of how they will consider that. Given that your daughter lives in the property, that is her residential home. So that can very much be argued that actually it's her residential property. She has a beneficial, equitable right and interest in that. If your daughter wasn't living there and was renting it out, I think you would very much struggle, because they would argue that it is a reservation, but because it's her residential home, you would be fine. What we need to consider is, when you go into care, what they will look at is your residence. What was your last residential property when you go into care? They will then check at the land registry the title deed, so they will look for the transactional trail. If they can prove that you gifted that asset without receiving any kind of consideration from that, whether it's a nil value or a small consideration, you've not received the market value, potentially they can argue that yes, there's an interest in it. What they can look at, if they do look to force you to sell that property, and it will be very much based on timeframes when you initially did the transfer, but they will look at the property itself. If they argue, well, actually, this property for my daughter, she's overhoused in this property, that it's too big for her needs, we could force sale of that to relieve some of the equity in that, what would allow you to pay for care, then potentially there can be an argument. The local authorities say are very different, and it's discretionary. A lot of the time, it's making sure you have the argument with them. Their initial view is, we want the money, but if you argue with them that this was in fact tax planning, it was done many years ago when I could not foresee that care was going to be something that I would need. It was done in a way that I actually built an annex for my end of life needs. You probably will get away with it. It's just making sure that you didn't hit that chargeable tax on the gift.
Thanks very much for that. If I give her that gift now of £1 million for the property and survive 7 years, there's no limit on what I can give her if I survive for 7 years. Is that correct? There's
no limit, but it is taxable. So you can only give your inheritance tax threshold during your lifetime. So you can only give £325,000 without it incurring a taxable charge immediately on the gift. So what you would need to do if you wanted to do it in a tax efficient way, you would give her £325,000 of the value of it now. So you would give a proportion of the property being your tax-free allowance. In 7 years, that tax-free allowance will start again. So you could then give her another £325,000 in 7 years, again, another 7 years, and it will start again. That is the only way that you would not hit a taxable charge immediately.
I was under the understanding that you could give anything away you liked, and as long as you survive for 7 years, it's not taxable. I've got that wrong then.
No, unfortunately, that's not the case. And that is really just to the 7 years PEP period, of course, is something, and it was to prevent people sort of on their end of life gifting money or doing bank transfers and moving millions of pounds out to avoid tax. But you can only give up to your tax threshold without hitting a chargeable tax. So you can give her the £1 million, but you will be taxed on 20% of anything over the £325,000. If you survive 7 years, there will be no additional tax to pay. If you don't survive the 7 years, you will pay the difference of what your inheritance tax would have been.
Right, okay. All right, thanks very much for all that.
Just to remind everybody that if you do want, because I personally find this all quite complicated, there's a lot of information to take in, and some people are sort of more up to speed with these things than others. So if you do want to have a 15-minute call with Alison separately to sort of go through the machinations of your scenario, then please do drop us a line, or Alison directly, or through my team. We can get something arranged. Anyway, so Harold Thompson asked, did that change since 1998?
Is that the change with the gifting of property, or? Sorry, Howard, I don't know if you can jump on and just confirm which element the change.
Howard, can you hear us?
I'm just typing.
Oh, sorry.
Yes. My father gifted a property to my brother and I in 1991. He didn't quite live out the 7 years, and I was just wondering how legislation changed since 1991 in terms of what you can give away in relation to a 7-year timescale.
No, that's not changed since that date. So it has been the same since that provision did take place. Of course, the nearer you live to the 7 years, so if someone passed away in year 5 or 6, for example, it tapers off the 40% tax down to your 16% at the final. So there is still tax benefits to gifting assets, because you potentially, even if you didn't survive the 7 years, we taper off the taxable amount. But no, it would have been exactly the same. What would have happened ordinarily when your father sadly passed away, the property would have been added back into his estate for the purposes of tax.
Right, yes, we were in the last year of taper, I think, if I remember correctly. Okay, thanks.
You're welcome.
Any other questions before we move on to the ones that have been sent in advance? No? Okay, so one of the questions we had was, could you explain the key components that would be included in a well-rounded estate plan?
Yes, so ordinarily when we look at estate planning, there is a number of elements that we'll look at. Sometimes ordinarily people say, well, it's just a tick box exercise, a will, as long as I've got something in place, that's all that we really need. But actually what we need to look at is all your circumstances, and that's not just your financial circumstances, but of course that is also relating to your personal circumstances, so your family dynamic. I think this has got more intricate, particularly as time has progressed, and that is more about vulnerable people and vulnerable adults, that we like to make sure that anything you're doing by way of estate planning, whether that's gifting assets in your lifetime, that you are retaining enough money that you know that you can live on. So it's making sure that you've got, in essence, an end-of-life financial plan, that if you are gifting assets or investing assets, that is going to give you either an income, or there's going to be some kind of element of capital that you are going to be comfortable in your circumstances. We also have to look at that a lot of people now, when they look to gift assets, they are gifting them to vulnerable individuals, and that can be vulnerable adults. That can be by virtue that they have mental health problems, that can be virtue of capacity issues, of physical capacity. So it's always making sure that it's the right elements for you. So in terms of a good estate plan, is very much looking at what your income needs are going to be, both now and in the future, what your capital needs will look like, what your living needs will look like, and what your family dynamic will look like. So is there any considerations we need to look at? It doesn't even just have to be vulnerabilities. We can see people approach us saying, well, I want my daughter to receive X amount of money, but I know she's in an abusive relationship. I know potentially that she's going to go through a divorce. So you need to factor that into your estate planning. Of course, again, these are things that are very uncertain, but to some extent, there may be elements that you're aware of, that you want to make sure that there are elements. It can be similarly that you are from a blended family, there's children from previous relationships. There is a worry that if the wills are not done correctly, assets can in essence bypass your children. And it's not unusual that we see people who are in blended relationships, blended families, that they will come and make wills, very much mirror wills, that everything will go to the surviving spouse, and then between all of our children respectively, a spouse passes away, the surviving spouse comes to us and actually says, we don't see his kids anymore. Actually, I only get birthday cards and Christmas cards, so I'm going to amend my will, I'm going to cut them out of the will. That's not unusual that we see a lot of stepchildren or even biological children be cut out of wills. And without the appropriate estate planning, it can mean that one, your children miss out because they've been cut out of wills in the future, or indeed that they end up in disputes because you've not properly provided. There is an element where people say, well, as long as I provide £5 for my kid in my will, he can't bring a claim against it. That's not correct. It's making sure that you have the right framework there, the right protection, and you've got the right advice on it.
Okay, thank you. Before I move on, any questions? Okay, so the next question, what are some of the common mistakes people make in estate planning, and how can they be avoided?
So I would say the most common mistake that I see is either people not using regulated firms. So as legal practices, we are fully regulated by the Solicitors Regulation Authority. Sadly, wills, power of attorneys, a lot of protection is not regulated work as it currently stands. That does mean that we see a lot of people who are will writers, as it were, but will writers drafting wills. As unregulated firms, we see that these people then can either go bankrupt or the companies can dissolve, and as a result your will can disappear. There is no regulation on where your will may be. So you may think that you've had a will writer, a company do your will, it's in their storage, An unregulated firm is not managed and governed. So as a result, the wills can disappear, meaning that you think you've got a will in place, but in actual fact, when it comes to transpiring, your family are looking for this, it cannot be located, and therefore automatically it's as if you did not have one. The courts will not look at any copy will. So even if you say, well, I've got a copy at home, so they know where the copy is, as far as the courts are concerned, a copy will never be deemed as a valid will. It has to be the original, unless it is with solicitors. The reason why they say unless with us, in I think it was 2007, we had the floods in Sheffield, what actually destroyed Howells, the solicitors Howells, their will bank was completely destroyed because they all kept in a storage unit, which is actually at Bridge Street in Sheffield. But because it's a regulated law firm, what they allowed was that, because there is a record of original wills, but because they knew that it was with a law firm to begin with, they allowed all them wills to stand as legal wills on the basis of a copy, because we're regulated firms. Similar law firms do cease to exist, they amalgamate, they merge with other law firms. If that happens and you find that the law firm where you got your will is no longer in existence, the Law Society, who again, through the SRA regulators, they have to be notified of all the wills, and they are notified where their wills have gone to. So ordinarily they will go to another law firm, but there is always a transactional trail of where your will may go and can be located. So not using a legal professional, in my view, I think can be quite risky. Or people will get the wills from WH Smith's that you can write your own wills, and you tend to find that these aren't actioned properly or executed properly. So for me, the biggest pitfall is not having them done with legal professionals and not getting proper advice on your circumstances.
Okay, thank you. Can you discuss the role of trusts in estate planning and how they differ from wills? We might have touched upon this earlier, but maybe a little bit more clarity would be good.
Yeah, so trust actually is, there's a number of trusts. Trust isn't just one thing, there's a number of trusts that are in existence. Some you can put in place in your lifetime, and some can be created on death by way of your wills. You have to consider whether a trust is a right thing. The reason I say that is because putting money into the trust is very much the same as gifting money. So potentially if you put £325,000 in a trust, it's non-taxable, but again, anything over that will have that taxable charge. It's the same way as gifting to the trust. The benefit of a trust really is you can detail how it's managed. So it allows the management to be undertaken by you, even though you no longer own the asset. So for example, you could say, right, well, I've got a rental property that I'm going to pop in trust for the benefit in the longer term of my children. But during my lifetime, I'm going to have full management of that trust. So it means that you are fully in control of the asset throughout your lifetime before it eventually being gifted to a third party. There's similarly different trusts such as bear trusts, and bear trusts are created for minors, so for children. Bear trusts can automatically end when the child reaches 18, meaning it's their asset. When we consider trust, do you need a trust? A lot, it used to be a very old-fashioned thing that was done, that everyone created trust, and very much wills were based on discretionary trusts. The reason we have to look at that is the tax elements to it. A lot of people don't realise that either there can be a tax fee of putting the money into trust, which there can be if it's over your threshold, but then there is a 10-year anniversary of any trust. So after every 10 years, there is a taxable anniversary that trust is taxable for a 10-year anniversary. So you have to factor in that, did you consider in 10 years that trust would incur a tax? If it's not, that you think you put it in trust and that's it, but actually you could have just gifted the asset, which makes it far more tax efficient to do. So it's looking at what's best for you. It's also considering is what is the purpose of the trust. If the trust is to mitigate care, so the idea is, well, if I gift an asset away, then I go into care, they can no longer access that asset. Again, you have to look at how the trust is set up. If you are potentially a beneficiary of the trust as well and have access to it, again, a local authority can say that it's still accessible by you and therefore you can take the money home. The perhaps most common trust that we come across is the property trusts. So this is something what is all originally generated by a will, so it's generated on death. So just as a basic example, so I know this doesn't fit everyone's criteria, but if you've got a husband and wife that came to us, they own a property, let's say at £500,000. Don't have too much more as far as other assets concerned, so we don't need to worry about inheritance tax. So we know we don't need to do any tax planning because their estate is under that tax threshold in any event. Their main concern is care, that should their health deteriorate and they go into care, they're worried that this asset is going to be used to fund their care. They currently have in place basic wills, everything to each other, and then it goes to the kids when they both pass away. If one of the spouses, let's say the husband just for ease, went into care and the wife is still living in the residential home, the residential home will be ignored for any financial assessment. Whenever one of you is dependent and owner and living in that property, they will not assess the property for any financial assessment. But should then the spouse living in the property, so the wife predeceased, so she passes away, that property becomes vacant, we still have the husband in care. The local authority then say we have a vacant property, we're going to force sale of that property and use it to fund the remainder of their care, which they of course will do. What a property trust does is it allows parties in their lifetime to actually give their respective share of the property to a different individual. So what we advise them is most people own their properties as joint owners, so in essence all of it together as one. We change the ownership for the husband and wife, meaning that they own it as two separate halves, so 50% each. On the wife's death, the first 50%, instead of going to the husband, in fact goes to the next beneficiaries, and just for ease we'll say the children. But it goes subject to a trust. And what that means is that the surviving spouse can continue to live there, they can generate income from there, they can do whatever they want with their property in their lifetime, all of it, without the children's interference. But if their health deteriorated and they had to go into care at a later date, the 50% was completely ring-fenced in a trust that cannot be touched by any local authority. There's no loopholes, there's nothing that can get through, it is completely ring-fenced. So whilst we've not safeguarded the whole value of the property, we've ring-fenced 50%, which is much better than potentially our 11,250. The reason that these wills were originally created were very much people on second relationships and marriages. It was to say, well, I actually want my half of the property to go back to my children, but I don't want my new spouse or partner to be either forced out, had to raise capital, get equity release or sell the house. I want them to live there for all of their life, but I never want them to be able to pass that money on to their children, or if they remarried, a new partner, their circumstances. So it's a way of, in essence, no matter the surviving partner or spouse's circumstances, on the second death, that 50% will always revert back to your beneficiary. So in essence, you are managing your asset even from the grave, that you can make sure that you know no matter what happens after your death, your 50% will pass back on the second death. Because of that, it mitigates care, so we know it's safeguarded, because I say it was a legitimate reason to be set up for previous children. It doesn't have to be, you can leave it to whomever you wish, but it does protect against care.
Just out of interest, how often should a trust be updated, and what trigger points are there for that?
Yeah, so with a trust that you're setting up in your lifetime, it's always important, depending what you've done it, because a lot of trusts can be investment trusts. So you tend to have these managed either by financial advisors or unless they're property. So you would annually always have a review of that trust, of how that trust is doing, the management of it, but also if the trust generates an income, there is going to be an income tax liability as well. So it's making sure that you are constantly reviewing that trust, that has it generated more money. If it has, the trust will pay tax on it. So it will be an income tax that's also paid on it. Similarly, the trust can also pay capital gains tax when it comes to end the trust. So if you've got an exit clause within that trust, they may also be capital gains, which is why I say it's so important to get information, and particularly on your circumstances about a trust, because you can go into the realms of income tax, capital gains tax, and if your taxable window, so your taxable 10-year chargeable taxable thresholds. So it's making sure you get the right advice. But annually for anything what is an investment trust, particularly because you've got to do your tax returns, but anything that's a trust by way of a property, once that's done after death, you don't really need to revisit that, because that trust just remains in place. There's no income payable on it. It's a non-taxable trust until, of course, the second passes away. And at that point, of course, you would manage it as you need to at that point.
Sorry, thank you, Alison. There's lots to take on. We've got two more questions, and then we can wrap up. So the penultimate question is, what are the potential tax implications of estate planning, and how can individuals minimise tax liabilities for their heirs?
Yeah, so exactly sort of the first question of what we look at when we initially do your estate planning is, what are your income needs? What are your capital needs? What is your family dynamic? At that point, we will look at your assets and see how we need to navigate your estate planning. We can look at your assets and say whether you will be a tax funder. If you are a tax funder, how we can mitigate that. There's lots of circumstances we could do. Which one is gifting, depending on you, particularly subject to your age, that we can look at gifting now with the hope you do survive for 7 years, because that creates a second tax-free element. We also look at investing in different scenarios. So I'm not a financial advisor, but I do know there are certain tax windows that you can get through that you do not need to survive 7 years, but only need to survive 2 years. But it's about getting the right advice on them. So they can, if you have significant wealth, particularly by way of cash, so ready capital, there are certain investments you can invest in which you only need to survive 2 years. But you can also be a beneficiary of those kind of investments. So it's looking at what is in your pot to begin with. We do have people that have significant pots, or they have business investments or something what is constantly generating money. With that, we look and recommend whole of life policies. So again, if we know we've done everything possible to try and mitigate it, but you're in a property what's worth £2 million, unless you're willing to sell that property and downsize, we know that you are potentially going to hit a taxable window on death. So we will look at different options, and this is where we work hand in hand with financial advisors of, actually, is it worth putting in place a whole of life policy, which in essence is an insurance policy, which will cover in any inheritance tax when it is payable. But you have to then weigh up how much are we paying in the premiums to what we'll receive at the end. But it can be worthwhile doing, particularly as I see it sometimes as, yes, you are paying a premium, but because it's a whole of life policy, it will pay out on death regardless of whether you have tax or not. So in essence, it's a savings for your loved ones and your beneficiaries.
Okay, and then last but not least, in what ways can individuals ensure that their estate planning wishes are communicated clearly to their loved ones and legally enforceable?
So a will is a legal document. So a will is a legally enforceable document. So as long as you have a will, it has to be followed by the book. So there is no way that you can potentially get around this or any changes. The reason why I think it's quite good to do it through legal professionals as well is that we ordinarily will offer to keep your wills in our storage. There isn't usually a charge. I know my firm, we don't charge for that service, and most firms don't. The banks used to, I think, used to pay a premium, something like £60 a year, but most law firms will not pay to hold your wills. The benefit of us holding your wills is that in the event of a death, we will always have your original document. If you have your original at home or you do a will yourself, the difficulty that you can find is that if someone comes to clear your house and comes across a will they don't particularly like, there's nothing stopping them from destroying that will. If no one's aware that that will was made, that original document can be a legal document that in essence could be destroyed by a third party. It could be destroyed by all of your family saying, well, we're not really happy with that because he was leaving X to the cat's home. Having it with solicitors means that it's fully protected. If you have got a family dynamic which is particularly complex, you have children or people what don't get on, they don't talk, or there's vulnerabilities, it's always sensible having your executors as either a legal capacity or in a professional capacity. More so because we have an obligation to make sure that your will is carried out, but it prevents any conflict between your respective executors, that you know that it will be done in the way that you want it to.
Okay. So yeah, a few people have obviously had to move on because of work or whatever. So we have no more questions. Are there any questions before we wrap up from our participants? I think that's everything. Okay, so sorry, one's just popped in now. Sorry. Okay. Paul Musgrove, thank you very much. Howard, I will email you, Alison. Yes, so to wrap up, thank you very much for joining, and a big thank you to Alison. There's a huge amount of information, massively helpful. There's a lot of things I'm going to go away personally and think about and start actioning. And yeah, I hope that you all got something from it. Please do get in contact directly with our team or Alison to arrange a 15-minute chat. Equally, if you're in the process of buying or building or looking or a property or whatever it may be in this journey, and need some help from iHus about planning applications, building control, build overs, drainage, build types, all that sort of thing, on the technical side of what we do, then feel free to drop my team a line and we'll be in touch. Equally, we can share the document with, we're happy to share the document with you. We have recorded the video, so that will be shared as well if you would like it. And I'm sorry that the camera's been messing around. I don't know what has happened with that today, but thank you very much for joining, and we will finish the webinar now. Thank you.
Thank you, take care.